In this episode, we talk about the provision of bail in cases handled by the Enforcement Directorate. We also talk about BJP leader Rekha Gupta taking oath as the Chief Minister of Delhi. But first, we talk about the appointment of the new Chief Election Commissioner. Hi, I am Niharika Nanda, and you are listening to Three Things, the Indian Express news show. On 17th February, Prime Minister Narendra Modi, Home Minister Amit Shah and Leader of Opposition Rahul Gandhi met for a meeting to appoint the new Chief Election Commissioner. Former IAS officer Gyanesh Kumar has been appointed as the new Chief Election Commissioner of India. Kumar followed Rajiv Kumar, who retired on Tuesday. The appointment happened in accordance with the Chief Election Commissioner and other election commissioners' Appointment, Condition of Service and Term of Office Act 2023. The law lays down a new procedure for the appointment of both the Chief Election Commissioner and the election commissioners. The meeting also saw Rahul Gandhi expressing his dissent. This was the first time that a selection panel had been set up to appoint the head of the country's election watchdog. To understand the new process by which this selection is made, the reason behind the change and Rahul Gandhi's dissent, we have the Indian Express's Chief of National Bureau, Ritika Chopra, joining us. Ritika, can you tell us about this recent meeting that happened between Prime Minister Narendra Modi, Home Minister Amit Shah, and the Leader of Opposition Rahul Gandhi for the appointment of the new Chief Election Commissioner?
So a meeting happened on Monday, that was Monday evening at the Prime Minister's office, like you mentioned, to appoint the new Chief Election Commissioner. The reason why this meeting kind of got the attention that it did was because this was the first time that the Chief Election Commissioner of the country was being appointed by way of a selection committee. What I mean by that is that earlier, what would happen is that the Chief Election Commissioner was appointed by way of seniority. So the Election Commission is a 3-member body made up of 1 Chief Election Commissioner and 2 Election Commissioners. I'd like to make it clear that in this case, the Chief Election Commissioner is like the first among equals. They're all equal, but he's the first among equals. A little bit like what happens in the Supreme Court, where the Chief Justice of India is the first among equals. What's happening this time around is that the new law that the government brought in 2023, that essentially laid down the process that was kind of cast in stone. And what was that process? The process was that there would be a short list of names that would be drawn up. This was both for the Chief Election Commissioner and the election commissioners, a short list of names to be drawn up. Ideally, a panel of 5. That shortlist would be drawn up by a committee which would be headed by the Law Minister, currently Arjun Ram Meghwal. And then that shortlist would go to a selection committee, and the selection committee had the Prime Minister, the Leader of Opposition, and a Union Minister appointed by the PM as the members. So it was Prime Minister Narendra Modi, Leader of Opposition being Rahul Gandhi, and the Union Minister appointed by Prime Minister Narendra Modi to this selection committee is Amit Shah. So these were the 3 members. They met on Monday, and by the end of it, even though Rahul Gandhi did give his dissent, a decision was made. His dissent was overruled, and Gyanesh Kumar was appointed as the Chief Election Commissioner. But with his elevation, a vacancy was created on the commission. As I mentioned earlier, it's a 3-member body. So to fill that vacancy, Vivek Joshi, the current Chief Secretary of the state of Haryana, was appointed as an election commissioner. So now it's again a 3-member body with Gyanesh Kumar as the CEC, Sukhbir Singh Sandhu, his colleague who was already on the commission, as the next in line in terms of seniority, followed by Vivek Joshi.
And Ritika, going slightly into the past, can you tell us how were election commissioners appointed previously?
So what would earlier happen was that once the Chief Election Commissioner, the incumbent person, was set to retire, the government would then, and that was the norm because we didn't really have a law for appointment for election commissioners and CECs. But at that point, the government would then appoint the next senior most election commissioner on the panel as the successor to the incumbent CEC. How do you define seniority given that they are all equals? It usually was by way of the timing of the appointment. So whoever got appointed first to the commission was the senior most, and then, of course, so on and so forth.
Right. And can you tell us a little bit about Gyanesh Kumar, the new Chief Election Commissioner of India?
So Gyanesh Kumar is an IAS officer of 1988 batch. Basically, he's known for his time spent at the Ministry of Home Affairs. He's perceived to be close to Amit Shah, and that perception comes from the fact that at the time when the government was planning abrogation of Article 370, which essentially scrapped statehood for Jammu and Kashmir and turned it into a union territory, there were very few people in the government who were involved in planning that, and Gyanesh Kumar was amongst the senior officers. He was an officer in MHA at that point, and he was amongst the very few people in the government who was entrusted with the responsibility of planning that. So yeah, he has, of course, spent time in other ministries as well, but that's one of his, I would say, one of the more important assignments that this government had given him during the time while he was still in civil service. In the current scenario, Rajiv Kumar, 18th of February was his last day in office. And the next person in line was Gyanesh Kumar. I would like to point out that this was a peculiar situation that both Gyanesh Kumar and Sukhbir Singh Sandhu, those were the other two election commissioners apart from Rajiv Kumar, they were both appointed to the commission on the same day. So you might ask then, who is the senior amongst the two? So we'd asked government officers and they'd said that, between the two, it was Gyanesh Kumar, because if you were to look at the Gazette notification announcing their appointment from March last year, Gyanesh Kumar's name comes first. And that's pretty much what is even followed at the time of appointment of Supreme Court judges. So going by the order in which their names appeared in the president's notification, Gyanesh Kumar was senior most. So again, pre-law, that's how the appointment would have happened.
And Ritika, from what we understand, there are certain petitions that have been filed in the Supreme Court against this new procedure of selection of the Chief Election Commissioner, which is also related to the reason why Rahul Gandhi expressed his dissent. So can you tell us a little bit about that?
So like I mentioned, there is a new law that came in which for the first time sort of cast in stone the selection process. Earlier, it was really the executive, the government of the day, which would decide who would be the CEC and ECs. But this time around, by way of a selection panel, of course, which had one leader of opposition as well. But after this act came in, Association for Democratic Reforms went to court along with other petitioners challenging this, saying that this law came in because of a clutch of petitions that were first filed in the Supreme Court, which first challenged the old way of appointing CEC and EC, which was that it was completely upon the discretion of the Prime Minister. The President, on the recommendation of the Prime Minister, would appoint it. So this was a completely sort of an internal exercise. It was considered to be opaque. So when the Supreme Court ruled in this matter, it was a very important ruling. The Supreme Court had some sort of strong observations to make on how, the government sort of had the last say on this. So the court at that point said that till the parliament enacts the law, the CEC and EC would be chosen by a selection committee made up of the PM, the LOP and the Chief Justice of India. But of course, the Supreme Court in its order had made it clear that this was until the Parliament brought a law. Eventually, when the Parliament, within a few months, when it did, in fact, the government was pretty quick to bring in a law, and even before a vacancy arose, what it did was that it changed the composition of the selection committee, and instead of the Chief Justice of India, there was now a union minister, like I earlier mentioned, who is nominated by the Prime Minister. The petitioners essentially objected to this, saying that this goes against the intention of the Supreme Court's order, and this is what was being challenged, and this is actually currently pending in court.
Right, and now that we understand the legalities of the situation, can you tell us the reason behind Rahul Gandhi's dissent?
Essentially, Rahul Gandhi's dissent was that this meeting of the PM, he himself, and the Home Minister should not happen unless the Supreme Court disposes of a legal challenge to the new appointment process. Till Monday, we were of the impression that the matter would next be heard on the 19th of February. And Rahul Gandhi's essential objection was that let the court dispose this off. A hearing's coming up very soon, so what is the hurry? So that was essentially his objections, that let's not do this in a hurry, let the court hear the challenge and see what it has to say about the current appointment process. That was its dissent.
But doesn't this new procedure with the provision of a shortlist give a slightly wider choice to choose from?
So there's definitely an additional person outside of the government who's now involved in the decision making. But of course, then the other argument or the other side to it is that the outsider here, the quote unquote outsider here, will be overruled just by the fact that the other two members on the committee are from the government. which is again why I said that the process is still being channeled, that the government, even in effect, would end up having the last say. Just as how what happened, as we saw on Monday, that while the LOP did object, the government said that you have the right to object. And in fact, from what we understand from the sources in the government, that his dissent was recorded as part of the proceedings of the meeting. But a decision was made nevertheless. Yes, under the current law, it's good to have a process sort of cast in stone. It's more transparent now, for sure. It helps, at least even for the process of selecting a chief election commissioner, it definitely helps the government cast a wider net. It doesn't now necessarily mean that the next guy in line or next senior most person on the commission will automatically be promoted to become the chief election commissioner. But what it doesn't address is that earlier too, it was the executive which had the final say in the appointment. And even now, in a way, by virtue of just the sheer game of numbers here, that the executive would still have final word on who gets appointed as the CEC and election commissioner.
Right. And Ritika, can you tell us about the eligibility criteria for making it to the shortlist in the first place?
So under the law, currently, the CC and both ECs are to be appointed from a panel of people who are currently holding or have held a position equivalent to the rank of Secretary to the Government of India. And also, it also states that the person should ideally have some knowledge about the conduct of elections, which frankly, anyone in the civil services would have an idea, because as a DM or whatever, you would have the officers serving in the government, whether it's state or the central government. Everybody sort of is roped in to conduct elections. So usually most civil service officers have that experience. What I'd like to mention is that even in the past, this is what was being done. What is different now, that this is now part of an act. But even in the past, if you look at the past chief election commissioners and ECs, they have all been retired civil servants, retired or incumbent civil servants. A majority of them are from the IAS, but there have been very few exceptions. The latest one being Sushil Chandra, who was a revenue services officer. But yes, a majority of them have, all of them have been civil servants in the past. It's just that now the act kind of, again, makes that more sort of concrete, and now it's part of law, that eligibility condition.
So Ritika, now that Ganesh Kumar has been appointed as the Chief Election Commissioner of India, will the petitions filed in the Supreme Court stop him from assuming his position?
So at the time when the petitioners were pressing for an early hearing, and this is just before, this was, if I'm not wrong, sometime last week, and what the petitioners were trying to impress upon the Supreme Court judges was that the incumbent is going to retire soon, so please hear this matter urgently. But at that point, the court had assured the petitioners that, whatever we decide, consequences would follow. So it's not as if once an appointment has been made, it can't be undone. At least that was the impression that we got, that whatever the court decides will stand. So frankly, this matter has not, there would be no clarity unless the court hears it. In fact, the court was supposed to hear the matter today, and it didn't. The bench rose before hearing this matter.
Next, we talk about a Supreme Court ruling that has turned back the clock on how bail is granted in cases under investigation by the Enforcement Directorate. The case in question involves Kanhaiya Prasad, who was accused of illegal sand mining in Bihar in 2023 and later arrested by the ED on charges of money laundering. Now, earlier this month, the Patna High Court granted Prasad bail in the matter, but the Supreme Court later overturned this decision and ordered him to surrender instead. To understand the significance of this ruling and its implication for future ED cases, my colleague Shashank Bhargava speaks to the Indian Express's Deeptiman Tiwary in this segment.
Deeptiman, the case we are talking about involves Kanhaiya Prasad, who is actually the son of JDU MLC Radha Charan Saha. Now, he was the one who had appealed his case in the High Court. Can you tell us on what basis had the High Court granted him bail, which the Supreme Court later set aside?
Okay, so the High Court said that, okay, fine, there is Section 45(1), which puts a condition that, when an application for bail is presented before the court has to give Enforcement Directorate's prosecutor a chance to oppose the bail. And once the prosecutor opposes the bail, the court has to be satisfied that prima facie there is no case made out against the accused. And only if the court is convinced that, the case does not stand, then bail should be given. Now, this is a very tough condition if the statute is read in letter. So the High Court, Patna High Court said that, okay, fine, this is what Section 45 says, but we do not think that if given some past judgments that we have seen in Patna High Court and in Supreme Court, they made certain references to them and they said that, we do not think that the intention of the statute is to put complete or absolute restraint on grant of bail. And basically, the court needs to use its discretion and analyze the circumstances of the accused and the circumstances of the case and the situation or the step on which the case at that point is currently standing. And taking into account all these things, it should take a decision. It also said that the way the ED had built its case, it was largely based on, confessional statements of other co-accused and on the statement of the accused himself. So they said that this is like a violation of a fundamental right where you are being forced to be a witness against yourself.
Yeah, and in that sense, the Prevention of Money Laundering Act is very different. For example, in a PMLA case, when the ED summons you, it does not tell you whether you're an accused or a witness. And also, unlike normal police procedures, statements made to the ED can be used against you in the court, which does not happen in an ordinary criminal case.
PMLA is the most draconian law in the country. PMLA is more draconian than UAPA, which is used against terrorists. Under the PMLA, it is the only law in the country where a statement made to an investigator is admissible as evidence in court. It is not admissible as evidence even under the UAPA. So that is why I say that PMLA is the most draconian law in the country. Its bail conditions are far more severe than even UAPA. So all in all, there is no law that is more stringent than PMLA in the country. So basically, the High Court looked at all these conditions that were applicable in the case. It also looked at certain previous decisions, such as it has quoted the decision of the Supreme Court in granting bail to P. Chidambaram, who was arrested in the INX media case by Enforcement Directorate in a similar manner and spent around 100 days behind bars. So it made a reference to those cases. Also some Makoka cases where there are similar conditions of bail and said that in those cases also bails have been given. It also reiterated that Supreme Court has held that bail is the rule and jail the exception. And so it gave bail to the accused.
Right, and what we saw basically was that, despite the High Court having quoted previous Supreme Court judgments and looking at previous cases, what we saw was that the Supreme Court set aside this order. So tell us, what reason did it give for doing that?
Okay, so in this judgment, the perusal of the judgment shows that the Supreme Court has merely read the letter of the law. And it has very expressly said that, the twin conditions of bail laid down in Section 45 of the PMLA have not been met, and so the bail cannot be granted. It has said that there is no finding whatsoever recorded in the impugned order, that is the order of the High Court, that there were reasonable grounds for believing that the respondent was not guilty of the alleged offence under the Act, and that he was not likely to commit any offence while on bail. Non-compliance of the mandatory requirements of Section 45 has, on the face of it, made the impugned order unsustainable and untenable in the eye of the law. This is the judgment. Basically, it has relied on Vijay Madan Lal Chaudhary versus Union of India judgment, which was given by Justice Khanwilkar in 2022. And it basically, in the face of several challenges to various provisions of the PMLA, it upheld almost all the provisions of the PMLA. And so in Justice Bela Trivedi's judgment in this case, in the present case, is basically a reiteration of the Vijay Madan Lal Chaudhary versus Union of India observations as far as the PMLA is concerned. And one could argue that it is a sort of turning the clock back, because since this judgment came, many provisions of this judgment have been sent back to the Apex Court for a review, and that process is still on. At the same time, the Supreme Court and several other benches of Supreme Court, it appeared, were taking a more considerate view of granting bail to accused under the Enforcement Directorate cases. And courts, despite while Section 45 remains under review, the courts have found ways to, circumvent saying that period of incarceration matters, because let's remember the maximum punishment under PMLA is 7 years. If a person is going to spend 3 years behind bars without any trial, that person has almost served half the sentence without being tried for the offense that he has committed. So what if he turns out to be innocent, at the end of the trial? So these are concerns that courts have.
Right. In so many of these cases, we have seen the process becoming the punishment. And in the past, we've also seen the court raise concerns about trials being delayed and the investigation being nowhere in sight. And the Supreme Court in the past few years has been sort of finding ways to give bail to the accused. Can you give some examples of that?
Okay, so, it all started with the bail of Manish Sisodia, where these two things were brought up, that the Supreme Court basically relaxed the twin conditions, saying that, Sisodia had undergone a long period of incarceration and that he had a right to speedy trial, and the possibility of a trial being concluded was not in sight in the near future. Similarly, BRS leader K. Kavita and AAP leader Vijay Nair were given bail in similar fashion. Jharkhand CM Hemant Soren's key aide Prem Prakash was also given bail in an ED case, reiterating that bail is the rule and jail is the exception. Even in Arvind Kejriwal's case, when he was arrested by Enforcement Directorate and given bail by a trial court in June 2024, the court heavily relied on Supreme Court observations and judgments and said that the Supreme Court of India has been encouraging trial courts to grant bail. So all these things have been happening in the past 2 years, and then comes this judgment which sort of says that nothing doing, I will just read the letter of the law and I will not grant bail because this is what the statute says and I don't know anything more than that. In fact, 2 days before this judgment came, Azam Khan was granted bail on the same grounds by the Supreme Court. And there too, the Allahabad High Court had refused bail. But Supreme Court set aside that judgment, saying that there is a long period of incarceration. Charge sheet has already been filed. So we don't see any reason why he should be kept behind bars. This is a case which is totally opposite. But obviously, when we are discussing this, we are only discussing points of law and we are not discussing the merits of the case or whether the accused is guilty or not. Let's remember that this Section 45 of the PMLA was struck down by the Supreme Court in 2017 in the Nikesh Tekchand Shah case. The court at that time had observed that the statute basically brought trial at the stage of bail, because if you have to prove your innocence at the stage of bail, then what's the point of a trial? So, but in 2022, as we saw in Vijay Madan Lal Chaudhary case, this entire thing was reversed and almost every provision of the PMLA was upheld by the Supreme Court.
And in the end, we talk about Delhi's new Chief Minister. Yesterday, BJP leader Rekha Gupta took oath as the Chief Minister of Delhi at the Ram Leela Maidan with senior BJP leaders including Prime Minister Narendra Modi, Union Home Minister Amit Shah and others in attendance. Delhi Cabinet Ministers Kapil Mishra and Parvesh Verma along with others were also sworn in as a part of the state government. Rekha Gupta is the only female BJP leader currently elevated to the office of a Chief Minister.
Rekha Gupta ईश्वर की शपथ लेती हूँ कि मैं विधि द्वारा स्थापित भारत के संविधान के प्रति सच्ची श्रद्धा और निष्ठा रखूंगी। मैं भारत की प्रभुता और अखंडता अक्षुण्ण रखूंगी। मैं मुख्यमंत्री के रूप में अपने कर्तव्यों का श्रद्धापूर्वक और शुद्ध अंतःकरण से निर्वहन करूंगी। मैं रेखा गुप्ता ईश्वर की शपथ लेती हूं कि जो विषय मुख्यमंत्री के रूप में मेरे विचार के लिए लाया जाएगा अथवा मुझे ज्ञात होगा, उसे किसी व्यक्ति या व्यक्तियों को तब के सिवाय जबकि ऐसे मुख्यमंत्री के रूप में अपने कर्तव्यों के सम्यक निर्वहन के लिए ऐसा करना अपेक्षित हो, मैं प्रत्यक्ष या अप्रत्यक्ष रूप से संसूचित या प्रकट नहीं करूंगी।
She is a first-time MLA from Shalimar Bagh and the fourth female CM of Delhi. Gupta had joined BJP in 2002 after spending nearly a decade as a member of the ABVP. She was also the General Secretary of Delhi BJP's Mahila Morcha and the National Vice Chairperson of the BJP Mahila Morcha. A seasoned councillor, Rekha Gupta contested the Delhi Assembly polls from Shalimar Bagh against Bandana Kumari, defeating the AAP candidate by 29,595 votes. While the BJP announced Rekha Gupta as the Chief Minister of the National Capital on Wednesday, the suspense over the Cabinet Ministers of Delhi ended yesterday after the Ministry of Home Affairs issued an official notification revealing the 6 Cabinet Ministers of Delhi, which included Parvesh Verma, Majinder Singh Sirsa, Ravindra Kumar Indraj, Kapil Mishra, Ashish Sood, and Pankaj Kumar Singh. You were listening to 3 Things by the Indian Express. Today's show was edited and mixed by Suresh Pawar and produced by Shashank, Bhargava, and me, Niharika, Nanda. If you like the show, then do subscribe to us wherever you get your podcasts. You can also recommend the show to someone you think will like it. Share it with a friend or someone in your family. It's the best way for people to get to know about us. You can also tweet us at Express Audio and write to us at podcasts@indianexpress.com.